Good morning, everybody. It's a great pleasure to be able to welcome you all this morning to the WG HART workshop on the subject of perspectives on jurisdiction and the criminal law. I know that this seminar has been planned for some time and has had to be postponed. It's a great shame that we're not able to welcome you all in person to London, but at least modern technology has come to the rescue once again and enables us to meet virtually. Indeed, it may have had a beneficial effect in permitting participation by scholars and practitioners from a wider range of jurisdictions. The program is fascinating. The organizers have assembled a most distinguished group of participants, and I'm sure that this will be a particularly valuable symposium. I'm only sorry that I'm prevented from joining you for its entirety, but it's good to know that the recorded presentations are available on the conference website, and that in due course, some of the papers will be published. Coming from a background as an international lawyer, I have long had an interest in this area of the ambit of national criminal laws and the scope of national criminal jurisdiction. From my time as an undergraduate, I was intrigued by the problems thrown up by cross-border crimes, by situations in which people shot at each other across frontiers, or blackmailed each other, or tried to defraud each other across international boundaries. Then, of course, there were questions about the extent of the realm and the ambit of the criminal law, the low water mark. What does the Queen and Cane actually decide? The Territorial Waters Jurisdiction Act of 1878, closing lines of bays and estuaries, pirate radio stations, offences committed on board British registered vessels on the high seas or in foreign ports, and offences on board foreign registered vessels in ports in the United Kingdom, affecting the peace and good order of the port. Quite early on in practice, I came across the Queen and Martin, a decision of Mr. Justice Devlin in 1956, in which the defendants had been charged with possession of opium on board a British registered aircraft flying from Bahrain to Singapore. Although there was jurisdiction under the Civil Aviation Act of 1949 over offences on board a British aircraft, the ambit of the substantive offences with which they were charged did not extend to the location in which the conduct took place. More recently, technological and legal advances have thrown up more and more novel possible locations for the commission of crime. For example, on or within 500 meters of an oil platform in a designated area of the UK continental shelf. See the Criminal Jurisdiction Offshore Activities Order 1987 and the Petroleum Act 1998, Section 10. On board the Eurostar as it crosses the midpoint of the Channel Tunnel. See the Channel Tunnel Act 1987, Section 10. And meanwhile, I find it enormously reassuring to know that the Outer Space Act of 1986, which extends to England and Wales, to Scotland, and to Northern Ireland, that is, to all three jurisdictions within the United Kingdom, applies to specified activities whether carried on in the United Kingdom or elsewhere, including any activity in outer space. The fascination of these situations is readily understandable, even if some of the examples might seem a bit quaint. But there's nothing quaint about the grave threat posed by international criminal activities on an increasingly broad plane. Drug trafficking, money laundering, online fraud, people trafficking, and perhaps above all terrorism, among other fields of criminal endeavor, present very real challenges to vital national and international interests. Nor is there anything quaint about piracy, which has seen a resurgence in modern times and has become a scourge of shipping in many parts of the world, including the shipping lanes off East Africa. Nations and their populations need the effective protection of the criminal law against international crime more than ever. In particular, the invention of the internet and the World Wide Web has opened a new dimension for criminal activities, and cyberspace is a new frontier posing wholly new challenges for regulation by the criminal law. Crimes could be said to be committed everywhere or nowhere in the ether. It may be entirely fortuitous where a server is located. It may be impossible to fix with any confidence the precise geographical location of an offence or an element of an offence, and the relevance of its location may be greatly diminished. The effective investigation and prosecution of international criminal activities have never faced greater challenges. In this jurisdiction, England and Wales, attempts have been made to keep abreast of these developments. I hesitate to mention these attempts in the presence of this most expert and distinguished audience, which will be all too familiar with them. Notably, the earlier approach adopted in judicial decisions whereby a crime was regarded as committed only where it was completed, see for example Harden and Stonehouse, a terminatory approach to jurisdiction, has fallen out of favour. I have to say that the old terminatory approach was clearly inadequate to meet the changing situation. In particular, it meant that many cases where the conduct had strong connection with this jurisdiction could not be tried here. It's been superseded by a more inclusive approach which accepts that a crime may be regarded as committed within the jurisdiction if a substantial part of the offence was committed in England and Wales. See Wallace Duncan Smith number 4 and Purdy and the DPP. In a parallel development, the Criminal Justice Act 1993 introduced special rules in respect of designated offences, principally theft, blackmail, handling, fraud, and forgery, and made separate provision for inchoate offences. This is not a straightforward matter. See, for example, Pogmore in 2017. The answer to the question, what measures are appropriate for the extension of the ambit of the criminal law and the jurisdiction of a state's courts, are likely to depend on the nature of the offence and the interests which it is sought to protect. One important development in recent decades has been the acknowledgement by international law that some criminal activities are so heinous or present such a threat to all nations that they require coordination of national criminal law and jurisdiction by agreement. Thus, for example, the UN Convention Against Torture provides that each state party shall ensure that all acts of torture as defined in the Convention are offences under its criminal law, Article 4, and shall establish its jurisdiction over such offences in widely defined circumstances, including where the alleged offender is present in any territory under its jurisdiction, and it does not extradite him to another state, Article 5. Further, a state party in whose territory an alleged offender is found is required either to extradite him or to submit the case to its authorities for the purpose of prosecution, Article 7. A similar approach is adopted by other treaties, including the Hague Convention for Suppression of Unlawful Seizure of Aircraft. Widespread participation in such conventions has led to the establishing of what comes close to a consensual universal jurisdiction in specific fields. These are areas where a consistency of purpose embodied in international agreements has resulted in a near uniform approach to certain of the most serious offences, although these new conventional regimes are not without their difficulties. That was certainly the experience of the Appellate Committee of the House of Lords when it considered the UN Convention Against Torture in the Pinochet litigation in 1999 and 2000, and it proved to be the case once again in 2019 when the Supreme Court considered the scope of the offence of torture in international law in the context of the civil war in Liberia in Reeves-Taylor. In the case of other criminal activities, those not subject to such international agreements, other difficulties are apparent. There are undoubtedly limitations and restrictions imposed by international law on the conduct of states in proscribing, investigating, and prosecuting crimes with an extraterritorial element. It's a characteristic of the criminal law and of criminal jurisdiction that they can give rise to intense controversy between states as to their proper limits. In particular, views may differ profoundly from state to state as to what standards should be applied and by whom. The problem here, I think, is that international law has never developed clear rules as to the limits of national criminal jurisdiction. Undoubtedly, some limits are set by the principle of the sovereignty and independence of states. Legislation of one state requiring conduct in a foreign state, which would be in breach of the laws of that state, or otherwise inconsistent with the sovereign right of that state to regulate activities within its own territory, is likely to amount to a violation of principles of international law. But short of such extreme situations lies a grey area of uncertainty. For example, in Serious Organised Crime Agency and Perry in 2013, the issue was whether Section 357 of the Proceeds of Crime Act 2002 authorised the imposition of a disclosure order on foreign persons out of the jurisdiction. So the case was concerned with the exercise of investigatory powers in criminal cases as opposed to curial jurisdiction over crime. The Supreme Court concluded that the legislation did not authorise the making of an order against persons out of the jurisdiction. And Lord Phillips observed, and I quote, "Subject to limited exceptions, it is contrary to international law for country A to purport to make criminal conduct in country B committed by persons who are not citizens of country A." Section 357 does not simply make proscribed conduct a criminal offence. It confers on a United Kingdom public authority the power to impose on persons positive obligations to provide information subject to criminal sanction in the event of non-compliance. To confer such authority in respect of persons outside the jurisdiction would be a particularly startling breach of international law, unquote. It's interesting that more recently, in another case before the Supreme Court, KBR and the director of the Serious Fraud Office in 2020, it was submitted by counsel for the appellant KBR that this reference to a breach of international law should be read as referring rather to a breach of comity in the sense of a non-binding usage. Comity between states is a concept which has been much criticized, although perhaps mainly when used as a claimed basis for declining jurisdiction in civil cases. However, it does seem to me that it has an important role to play when seeking to delimit the appropriate scope of application of national systems of criminal law. That role is all the more important because of the lack of clear binding rules of customary international law. The Supreme Court did touch on this in its recent judgment in KBR. I was a member of the court in that case, and I say nothing about the merits or demerits of the decision. I leave that to you and others on another occasion when I'm not present. The Supreme Court in KBR cited Judge Crawford's explanation of comity as something less than a rule of international law, whereby certain usages are carried on out of courtesy and are not articulated or claimed as legal requirements. It is, he says, a species of accommodation involving neighborliness, mutual respect, and the friendly waiver of technicalities. As a concept, it's far from a binding norm, but it's more than mere courtesy exercised between state courts. In KBR, we suggested that the presumption in our legal system against the extraterritorial application of legislation was founded in part on such a principle of comity. Comity possesses the great advantage that it's capable of providing a degree of lubrication to machinery, which lacks clear hierarchical rules in customary international law. It does, however, have the disadvantage that its content is not clearly defined. It may be that there is valuable work to be done in seeking to define principles according to which there might be addressed the appropriateness of exercising extraterritorial jurisdiction, whether in proscribing, investigating, or prosecuting criminal activity. The timing of this workshop is particularly opportune. Jurisdiction in the criminal law is not only a rich field for scholarship, but also an area in which the law faces greater challenges than ever before on so many different fronts. It's particularly pleasing that such a distinguished group of scholars and practitioners should be assembled to debate these pressing issues. I have no doubt that your deliberations will be fruitful and highly influential in the future development of the law, and I wish you all a very enjoyable and productive conference. Thank you very much.
So thank you very much for the invitation. I think indeed that jurisdiction is a very important concept in cyberspaces, and I want to take you back to the beginnings of what I will call text-driven jurisdiction, to have a look at how technologies have afforded modern positive law means I'm basically involving a philosophy of technology to better understand the law, which has become very important the moment when the technologies in which the law, the rule of law, jurisdictions are articulated are changing from text to code and data. So jurisdiction is a strange animal. Over the past couple of centuries, it has consolidated into a stable identifier, providing clarity on who are under whose rule, aligned with the exclusiveness that is core to internal sovereignty, taking external sovereignty for granted. With the rise of the modern state, jurisdiction became tied to territory and secured as what provides for legal certainty in the everyday context. Within that context, legal theories such as that of Kelsen or HART could be read without much mention of the monopoly of violence or the sovereign whose monopolist and exclusivist claims actually enabled a highly productive, neutral, apolitical understanding of law and legal certainty. Nonnet and Selznick, quite some time ago, have coined this the historic bargain whereby politics abstained from interfering in the daily operations of the law, guaranteeing the independence of the judiciary in exchange for law not interfering in politics, understood by legal positivism as the separation of law and politics. Of course, this particular architecture of law, state, and jurisdiction was itself both a political and a constitutional arrangements based on, but also requiring, a normative engagement of politicians and of lawyers, because the justification of such a bargain can only be that politics abides by the rule of law, while the courts abide by the spirit of the law, as enacted by the legislature and the courts. There is, of course, nothing neutral about that architecture, and I will return to what Montesquieu called the spirit of the law, what others have called its implied philosophy, or the social contract, as specific to this particular arrangement that we usually call the rule of law or the rechtsstaat. Times are changing. I want to focus in this talk on the rise of brute jurisdictions. Let's take first one example. Facebook, with over 2.7 billion users around the globe, has instituted an oversight board to decide on the removal of content by the network. In its very short lifespan, it has already received 200,000 requests. The members of the board are decided by the network. They are reimbursed by an independent foundation funded by the network. The jurisdiction, the power, the competence of the court, the oversight board, the relevant procedures and the applicable law are stipulated in a brief charter that clarifies default allegiance to the freedom of expression, that's on top, but it acknowledges there are limits that demand the removal of specified content. And the charter stipulates that the applicable law is the values of the network, of Facebook, and prior decisions of the board. Second example is Google and Apple that control most of the global mobile infrastructure. And during the pandemic, they banded together to code, to develop a COVID exposure notification into their operating system or software under the heading of privacy. And it basically means that their systems decide what data public health authorities and governments do and do not have access to. Though the powers of the oversight board and the affordances of the exposure notification infrastructure do not contain punitive measures, they do demonstrate that jurisdiction as we know it finds itself in the company of new types of jurisdictions that bypass the powers of the state, while nevertheless making decisions with a clear performative effect. And I'm going to call these jurisdictions brute jurisdictions as compared to those that are institutionalized within the framework of national and international law. Let's go back to jurisdiction as we know it. Brute jurisdiction actually challenges the state's monopoly on the making and speaking of law, which is rooted in territorial jurisdiction. In my talk today, I will not only suggest that due to the advent of cyberspace, this monopoly can no longer be taken for granted. I will also argue that the performative effect of territorial jurisdiction was an affordance of two specific technologies, cartography and the printing press, highlighting that we cannot assume similar affordances as those of cartography and the printing press when it comes to the technologies that ground cyberspace. Let's first note that the concept of jurisdiction preceded that of territory. Whereas jurisdiction appeared in the early 14th century when it referred to the scope of administrative power, territory appeared a century later, and it then meant land under a specific jurisdiction, for instance, of a town or a state. Jurisdiction determined the reach of governmental power, which could be based on what we call ratione personae. The clergy, for instance, fell under the powers of the Pope, ratione materiae. Marriage fell within the power of the Catholic Church, or ratione territoriae. Whoever lived on a particular stretch of land fell under the powers of a particular lord. Second, let's note that these jurisdictions overlapped and competed and did not depend on the idea of a sovereign state. Harold Berman and Patrick H. Glenn both saliently described the rise of the state's monopolistic claims of territorial jurisdiction versus all other kinds of jurisdiction, basically culminating in the birth of the sovereign state as an entity that combines protection against external interventions with internally the complete and highest power, thus allowing for the idea of external and internal sovereignty to crystallize as two sides of the same coin. If you don't have external sovereignty, you cannot make true your internal sovereignty because you cannot protect your people. And if you do not have internal sovereignty, other states will not recognize you. So how come the reach and scope of jurisdiction shifted towards the end of the Middle Ages towards territory as an exclusive way to ground the exercise of governmental power? What technology, as a philosopher of technology or a historian of technology, what technology may have afforded this shift? Let's first look at cartography. In his seminal work, Ford has highlighted how the technology of cartography introduced a new type of spatiality, as it enabled to map the surface of the Earth by drawing lines and thus dividing it in mutually exclusive and closed spaces. This facilitated first a shift from authority based on family to one based on territory. Second, providing unambiguous boundaries for the exercise of such authority. Third, creating an abstract spatiality that does not depend on the specific texture or habitation of the land that is demarcated. Thus, fourth, basically mapping a series of bounded empty spaces that cover the entire surface of the Earth, with the exception of the high seas. Cartography thus afforded a kind of abstraction that is characteristic of modern statehood, where the sovereign is an office, an empty place, rather than a particular person, placeholder, as similarly described by, for instance, Kantorowicz in The King's Two Bodies, and further developed by Claude Lefort, who spoke of the locus of power in a constitutional democracy as an empty space. Here we see that such abstraction is not a human invention based on the genius of a single person or based on the genius of a superior civilization, but on affordance of a specific technology. This is, of course, not to suggest technological determinism. An affordance enables and constrains, depending on how the technology is used and embedded. It either induces or inhibits. It enforces or precludes. In other words, technology is neither good nor bad, but never neutral. Let's look at the printing press. As Eisenstein and others have demonstrated, the affordances of the printing press differ from those of orality, but also from those of the handwritten manuscript, in particular with regard to the need for systematicity and abstraction. Scholarship on the history of information confirms that writing and printing gave rise to abstract thought, rather than this being a feature of the human mind in splendid isolation. Writing affords distantiation between author and text, between text and reader, between meaning and text, both in time and in space. This is how text enables societies to organize themselves into larger communities, distanciation in space, while planning ahead further, longer time span, distanciation in time. Writing affords to externalize a collective memory that can also serve as a repository of the rules a society lives by, while the proliferation of identical printed copies of text afforded the enactment of statutory law meant to bind all subjects. The rise of modern positive law over the course of 5 or 6 centuries is thus tied up with the possibility to enact written legal statutes or case law, written legal speech acts, that have legal effect for all those who share the relevant jurisdiction. Let's now dive a bit deeper into this notion of binding legal norms and the idea of legal effect. And I will do that under the heading of written legal speech act. Speech act theory builds on the idea that speaking is a form of acting. As such, it was first developed by Austin in his How to Do Things with Words, who spoke of performative speech acts or performatives whenever an utterance does what it says, such as when a civil servant declares a couple husband and wife. The nature of such performatives is not causal, but constitutive of its effect. The civil servant does not cause the marriage, but nevertheless brings it about. Searle further developed speech act theory by introducing the concepts of institutional and brute facts, where a table or a stone are considered brute facts, marriage or contract are considered institutional facts, being the result of performative speech acts. Speech act theory provides the most salient account of what happens when the law attributes legal effect to an action or a state of affairs. Both Anscombe and McCormick paid detailed attention to the background knowledge that is implied in speech acts. They did so in terms of the context that is assumed when navigating institutional facts, highlighting the fact that in normal circumstances, such tacit background knowledge doesn't need to be specified. And though this may be true in face-to-face situations, it can, of course, not be assumed in the case of written speech acts, which is the stuff modern positive law is made of. This explains the complexity of our legal systems, where background knowledge must be made explicit to provide legal certainty, at least to some extent. It also explains the success of territorial jurisdiction, because that allowed to restrict the reach of written legal speech act to the territory of a sovereign state, thus constituting an artificial demos, people, consisting of all those on that same territory who didn't necessarily connect with each other. This demos, no longer bound by kinship or local custom, requires something like an unwritten social contract, a fabric of background knowledge to underpin the written law, thus constituting what Montesquieu called the spirit of the law. For legal enactments to have performative effect, like in the case of marriage, so legal effect, for them to be interpretable and for them to perform closure, to provide, in other words, legal certainty, a demos cannot span the entire globe, as this would disturb the delicate balance between written legal speech act and the tacit understanding on which it thrives. Now let's move on to competing jurisdictions in cyberspace. By default, cyberspatial context is not geographically defined and is not contained within national boundaries, which raises complex issues of jurisdiction where principles of international law like territory, personality, and effects doctrine do not solve problems, but rather create them. If context is what enables the performative effect of legal written speech acts, then the loss of an identifiable context may disable the kind of legal protection offered by modern positive law. In their salient work on rethinking the jurisprudence of cyberspace, Reed and Murray speak of competing normativities as a core challenge to the rule of law in cyberspace. The cross-border nature of cyberspace enables a continued workflow of deterritorialization and re-territorialization that enables both natural persons and legal persons to seamlessly trade, steal, and target across national borders without them actually crossing any physical border. Cyberspace thus generates a diversity of claims, for instance, in terms of criminal law enforcement for extraterritorial jurisdiction, basically based on the effects doctrine, that in turn generate a new type of pluralism as to applicable law and competent courts. As states grasp cross-border jurisdiction based on a variety of legal relevant leads, subject matter, effects, personality, territory, cyberspace results in legal and natural persons facing a potentially contradictory set of legal obligations they cannot possibly all comply with. And I think Reed and Murray are right in arguing that this seems to overrule many of the assumptions that underlie the monopolistic claims of territorial jurisdiction, which grounds not only positive law, but also the rule of law. There is no protection of human rights if there is no exclusive jurisdiction. I would not, however, agree that this situation of a plurality of sometimes contradictory legal obligations creates a new kind of freedom to choose one's jurisdiction depending on individual preference, or to develop an individualized law based on the spot and temporary community of those who decide to comply with the same legal norm. Though I have no doubt that some of the big players at the global level are capable of cherry-picking the rules they abide by, most of us cannot afford such luxury. Now let's move towards brute jurisdiction. There is another type of jurisdiction which I have hinted at when discussing the examples of the Oversight Board and the exposure notification of big tech companies both. This is not about competing legal jurisdictions, but about the de facto performative effect of cross-border code-driven infrastructures, social media tech platforms, decentralized autonomous organizations. This may concern the darknet, where child pornography flourishes, challenging the non-intervention principle that grounds territorial jurisdiction, because justice authorities will seek ways to hack into remote data service. It can concern the use of autonomous weapons, remotely steered in cross-border conflicts where war has not been declared, challenging the Geneva Conventions by way of targeted killings on foreign territory. It, of course, also refers to industrial espionage, undermining of elections by way of sophisticated malware capable of disrupting critical infrastructure, inviting further erosion of the principle of non-intervention. The performative effect that informs these new brute jurisdictions is fundamentally different from that of written legal speech acts. These brute performative effects induce or even force us to behave in certain ways that are not agreed as part of a social contract. They may also inhibit or overrule our action potential, often without us even noticing how we are being constrained and nudged. There is a normative force of the factual here, which is not only a matter of new kinds of habits and expectations due to the proliferation of the smartphone, video conferencing, search engines, and e-commerce, but in the first place are a result of brute technological force that automates the behavior of machines that are largely hidden between the surface of everyday life. And this has major consequences for criminal law jurisdiction. One of the reasons why the EU has limited power, limited jurisdiction in the domain of criminal law is due to the criminal law's close alignment with sovereignty, because the jus puniendi is tied up with a monopoly of violence that prohibits taking the law in one's own hand. Another reason is that criminal law is not merely about compensation of harm caused, but about the imposition of a fine or detention meant to censure actions considered wrongful. In a sense, criminal law is closer to the moral backbone of a demos than private and public law. It is part of the social contract that defines the demos, because criminal law signals indignation about the violation of legal norms that define and sustain the spirit of the law. In other work, I have argued that a European criminal law would require, and could at the same time institute, a distinct European identity and thus a European demos, noting that one can identify with more than one demos and that the demos integrates difference rather than necessarily imposing homogeneity. The plurality that enables a person to identify with more than one demos and the plurality that is inherent in one and the same demos do, however, not mean that anything goes. We cannot go around and cherry-pick the jurisdiction that condones our actions. And the plurality of opinion within a demos assumes enforceable standards based on shared values. Law is not equivalent with morality. We can disagree on what should be done from our different moral perspectives, but we need at some point closure when it comes down to a part that is enforceable law. And that is a good reason, of course, to be sparse with criminalization and to be cautious about imposing legal obligations to criminalize in inter or supranational law. Cyberspatial jurisdiction, however, may punish and prosecute by way of the force of technology, that is, the performative effects of the code it deploys. This is not grounded in any social contract, but imposed by, for instance, big tech companies that control the global infrastructure of, for instance, mobile applications. As lawyers, we should get our act together. The rule of law is a historical artifact afforded by specific technologies. To sustain the rule of law, we must figure out what affordances are crucial here and how they fare in code and date-driven jurisdictions. If we do not get to that point sooner than later, the normative force of brute jurisdiction may take over, and we may not even remember why countervailing powers slow down innovation, diminish efficiency, but will nevertheless prove resilient and robust in the face of unwarranted and unaccountable brute facts and brute force. Thank you.
My presentation may have a somewhat mysterious title, but my aim is really to discuss jurisdictional shifts in criminal law enforcement on the high seas and in cyberspace. I call these spaces aterritorial zones. They're actually places in between with the attendant jurisdictional challenges. And my focus is really on the challenges regarding enforcement jurisdiction. And as you may know, enforcement jurisdiction is interpreted narrowly in line with the Lotus Principle, as we know, the prohibition of extraterritorial enforcement jurisdiction. Enforcement jurisdiction is the last bastion, I would say, of jurisdictional territoriality. On the high seas, for instance, only flag states have enforcement jurisdiction, with perhaps a limited exception for piracy, which will also be addressed in this conference. And in cyberspace, only the state where the evidence, the data is located has enforcement jurisdiction. That is, in principle. Other states have, in principle, no jurisdiction. But from a law enforcement perspective, this may seem to be undesirable, as it may create safe havens for criminals. So it is not surprising that some states have decided to go it alone, apparently unrestrained, unconstrained by international law limitations. And they have exercised enforcement jurisdiction over the smuggling of migrants and drugs, narcotics, on the high seas. Marta Minetti has also referred to this in a previous panel. And in cyberspace, law enforcement authorities have ordered internet service providers to produce data stored abroad, and they have even accessed such data directly via governmental hacking techniques. And Mireille Hildebrand and Daryl Brown have all already referred to this in previous panels. And other speakers, especially on the third day of this conference, will do so as well. Let me go to my next slide. I'll make two claims in my presentation. You see them clearly on the screen here. My first claim is, when justifying their enforcement jurisdiction, states seem to rely, quite interestingly in fact, on principles of prescriptive jurisdiction. And they do so, not surprisingly, because prescriptive jurisdiction with the permissive principles, you know, gives them more options to exercise enforcement jurisdiction. But clearly, this blurs the existing doctrinal distinction between, on the one hand, prescription, more liberal, and enforcement jurisdiction, more strictly interpreted. Second, I make a normative claim. The expansion of extraterritorial enforcement jurisdiction may be justified under limited, carefully defined circumstances, balancing law enforcement utilitarianism and countervailing interests or rights even of third states, private operators, and individuals. Let me go to my next slide on smuggling. Smuggling on the high seas. Well, as we know, and this has already been explained earlier today for those who joined that panel, states are confronted with the smuggling or the trafficking, that term is also used, of migrants on the high seas. Think about the Mediterranean Sea. And they're also confronted with the smuggling of drugs or narcotics on the high seas. So the question then is, can states arrest the smugglers? Could they confiscate their boats or destroy their boats? I mean, that's a very straightforward question, an easy question, you could say, but the answer is quite complicated. So this is a question about the exercise of extraterritorial enforcement jurisdiction. First, migrant smuggling or trafficking. So some states, including European states, also the United States, well, more powerful states, we can come to that later, perhaps in the discussion, because from an international perspective, this is quite interesting. We have a limited number of states exercising this jurisdiction, but these states believe that they can take so-called appropriate measures when interdicting smuggling vessels, and typically we talk here about stateless vessels. And these appropriate measures include, as already indicated, arrest, confiscation on the high seas, arrest, and then later prosecution in, for instance, Italy, to give just one example. But I will focus on enforcement jurisdiction. The problem here is that we have a convention, the UN Convention on the Law of the Sea. For those who are a bit familiar with international law of the sea, it only authorizes inspection and boarding of such stateless vessels, not arrest and confiscation. Okay, then there is this migrant smuggling protocol. Some presenters have already referred to this. It's a protocol to the UN Convention Against Transnational Crime, and it mentions indeed appropriate measures. But it doesn't clarify what it means. Does it include enforcement jurisdiction? We simply do not know. So I believe that at the end of the day, only customary international law, yes, I'm a public international lawyer, so I refer to the sources of international law here, unwritten customary international law can provide the legal basis for this type of extraterritorial enforcement jurisdiction. And interestingly, there is a decision of an Italian court, actually the Supreme Court, the Court of Cassation, regarding precisely the arrest and prosecution of a smuggler, a trafficker, which appears to base Italy's enforcement jurisdiction on the high seas on the protective principle and the universality principle. But hey, these are permissive principles of prescriptive jurisdiction. So what we're seeing here is a conflation of prescription and enforcement. Let me go to my next slide on drug smuggling. My claim is that a similar dynamic appears to be at play in the United States regarding the smuggling of narcotics. Under the US Maritime Drug Law Enforcement Act, the US exercises enforcement jurisdiction over, again, stateless vessels, this time involved in drug smuggling on the high seas of the US coast. Also over foreign flag vessels, to the extent that the United States has obtained, typically prior, consent for enforcement action via shipboarding agreements which have been agreed on between the US and another state. These are bilateral deals, but I focus on the stateless vessels in my presentation now. Again, there is no clear treaty basis for such operations, at least not against these stateless vessels. The treaties, they only say that states should cooperate in the suppression of illicit traffic in narcotic drugs. And so they don't talk about enforcement jurisdiction, not on a unilateral basis. So the authority for arrest and detention, again, needs to be derived from customary international law. And again, it appears that the law of prescriptive jurisdiction, permissive principles, are relied on to justify enforcement jurisdiction. So in the practice of the United States, we see ample references to the protective and the universality principles. So there's quite some court litigation, quite a number of court cases in this respect. But again, from our perspective, collapsing the distinction between prescription and enforcement. Let me go to my next slide on the lawfulness of maritime law enforcement against smuggling. Are these practices internationally lawful? And so that's more a normative international law perspective that I'm espousing here. Well, state practice, as already indicated, remains limited. We have some Western states carrying out these operations. So clearly, there is a risk of hegemonic imposition. Theo Coventry, for instance, has recently argued that in an academic paper. But at the same time, there is only limited international protests. Not surprising, because there is no state to protest in case of stateless vessels. But I would like to add here that the legitimacy and even the legality of these enforcement practices could perhaps be derived from shared international norms laid down in the Migrant Smuggling Protocol or the Drug Trafficking Convention, the Vienna Convention of 1988. And Maggie Gardner, writing in the Harvard International Law Journal a few years ago, has used the term channeled unilateralism in this context. This is unilateral action, but it's relied on to make international, transnational criminal law conventions more effective. This idea has been developed in the field of prescriptive jurisdiction, but why not apply it to enforcement jurisdiction? It's a bit of a question mark still, so remains up for discussion. Let me now move to the second part of my presentation. This is about enforcement jurisdiction in cyberspace. My claim is that in cyberspace, we actually see a more or less similar relaxation of the prohibition of extraterritorial enforcement jurisdiction. And the question here is whether law enforcement authorities can unilaterally access data held abroad on a server, on a computer, or a device that located abroad, without relying on mutual legal assistance treaties, so not using the bilateral or multilateral avenue. And in practice, as many of you know, states do this via unilateral or sometimes called extraterritorial production orders, or rarely via direct access of those devices. So this is what we call hacking, governmental hacking. This is an issue, of course, that will be addressed in other presentations, but my focus here is on the international jurisdictional justification of the practice. So the advocates of the practice claim that the mere territorial location of digital data on a particular server is not dispositive, is not decisive for purposes of exercising enforcement jurisdiction. So the Lotus prohibition does not apply, and instead one should pay heed to other connecting factors. Comity, perhaps. These connecting factors are being drawn from the law of prescriptive jurisdiction, and ultimately, I would say, even from private international law. And this is basically a new form of investigative jurisdiction applied only in cyberspace. I would not extend it to other fields. But this new form is not that new, I have to say. It has its roots in an older practice, a US practice mainly, of extraterritorial discovery orders, orders for the production of documents held abroad, located abroad, at the time still documents, these days we talk about data, at the time also under the threat of a subpoena. And at the time this was conceived by the great jurisdictional jurist Francis Mann as a form of, and I quote, indirect extraterritorial enforcement jurisdiction. And interestingly also at that time, this extraterritoriality was already being justified and mitigated on the basis of principles of prescriptive jurisdiction, territoriality to a certain extent, but mainly jurisdictional reasonableness, interest balancing, and comity, right? Let me go to my next slide. Prescription informing enforcement. Fast forward to the 21st century. We see a similar picture. For instance, in Public Prosecutor versus Yahoo, a 2015 case, we have a similar case, Public Prosecutor versus Skype in Belgium. A Belgian public prosecutor attempted to obtain subscriber information from the US-based internet service provider Yahoo, and the Belgian Supreme Court justified this action on the basis that Belgian law applied to, and I quote again, any operator or service provider which actively directs its economic activity, its business, to consumers in Belgium, data subjects in Belgium. Really, this is a territorial targeting approach drawn from the law of prescriptive jurisdiction, and ultimately, I would even say from the law from consumer law, actually, private law and private international law. It even appears to me that states somehow see enforcement as parasitic on prescription. Then the argument is, if there is prescriptive jurisdiction over the underlying crime, there is necessarily also enforcement jurisdiction regarding criminal evidence in relation to that crime, regardless of location. A location doesn't matter anymore in this scheme. But of course, if you espouse such a position, it would dramatically expand the scope of enforcement jurisdiction. So what we see is a quest for limitation, again inspired by the law of prescriptive jurisdiction, also by human rights, by the way. Perhaps we can leave that for the discussion or for day 3. My focus here is really on jurisdictional aspects in the strict sense of the word. So the argument then goes, extraterritorial enforcement is fine if it relates, for instance, to your own nationals or your residents' data. Or or a very popular argument as well, if it relates to serious crimes. And most often, states actually rely on a variety of connecting factors, connecting interests, basically, again, applying notions of jurisdictional reasonableness, a notion, of course, with a lot of flexibility. And we heard that very early today. So again, the takeaway is we see a conflation of prescription and enforcement, but normatively, it is a process that I would cautiously perhaps support. Technology evolves, we know that. So the law and the law of jurisdiction may and should evolve too. And the territorial location of data at the end of the day may just be incidental and may sometimes not even be known. So it cannot really be the jurisdictional linchpin. Now, we know that the jurisdictional quest is ongoing. We have the US Cloud Act. There is the EU production order that is currently in the pipeline. Let's see what comes out of this. A lot of pushback against that from a human rights perspective, mainly. There's a second additional protocol to the Cybercrime Convention, the Budapest Convention of 2001, which is being prepared. Not sure whether that will be successful. What is the interrelationship with the EU production order? Not fully clear yet. But note, and this is what I really would like to emphasize as an international lawyer, this is a particularly Western thing. And all these things come with a particularly Western slant. States such as Russia and China, they still stick to the principle of strict territorial enforcement. They would treat digital evidence as basically any other piece of evidence. So it's also easy for them to do, as you know, they have data localization requirements. All the data have to be stored in the territory, and then law enforcement authorities can easily access those data. You don't need production orders. You don't need to hack into a computer abroad. Let me then go to my final slides. Michael, if I may, I only need 1 minute, so then I will remain within the allotted time, I hope. Concluding remarks. There has been a push to relax the prohibition of extraterritorial enforcement jurisdiction on the high seas, cyberspace, or the so-called aterritorial areas, aterritorial zones. It's not yet fully clear to me how these practices should be understood from an international law perspective, because there is no clear treaty authorization, and customary international law, at least at the universal level, remains ambiguous. Maybe at the regional level or the bilateral level, things are going to change, and that is a possibility, of course, bilateral regional custom. But speaking from a general, a universal perspective, really very ambiguous, and, well, I would say the law is absent there. But in my presentation, I have offered some leads on how these practices could potentially be justified. On the one hand, I believe that we should take seriously the impunity concerns of the law enforcement community. That's one side of the equation. But the other side of the equation is that we should make sure that sufficient safeguards are in place. Of course, I don't have time to elaborate on that in detail, but let's briefly go to law enforcement on the high seas. Arguably, this should be limited to stateless vessels in relation to shared international concerns laid down, preferably in international conventions. And an interesting question in this context is, for me, for instance, whether unilateral enforcement action would be possible against illegal, unregulated, and unreported fishing, which tends to be dominated, for those who don't know that, but is dominated by transnational criminal organizations. And so from a criminal law perspective, there's some interesting work to be done. Secondly, law enforcement in cyberspace should pay heed to the interests, of course, the issuing state, but not just the issuing state, also the state where the internet intermediary is located, possibly the state of data location, as well as the rights of the accused, the rights of the data subject. And Julia Hörnle, who will speak later at this conference, has a lot of interesting things to say about this. She recently published a book on internet jurisdiction espousing this human rights perspective. So any questions on human rights are better directed at her. So I'm sure we will hear more about all those issues, and especially the latter issue on cyberspace and jurisdiction later in this conference, especially also on the enforcement dimension. I would leave it here.